So in this morning's first panel, obviously the speakers covered a lot of ground, a lot of different subjects, and one topic they returned to a few times was the issue of public sector unions. And so we're very happy now to have a panel discussion with experts focused specifically on that important subject. It'll be moderated by a familiar face at our programs, Professor Joanne Koob. Joanne's our colleague at the George Mason University Scalia Law School. Our program is actually one of several in a sort of a constellation of centers at the law school. First and foremost, the Law and Economics Center, other programs on national security, intellectual property, antitrust, and so on. Joanne directs the Center for Law and Liberty that does very important and good work. I hope you'll check out their website. As a big fan of both law and liberty, I'm a fan of the center. And Joanne, thank you very much for joining us today.
Thank you, Adam. Well, I'm excited to be moderating the panel today on public sector unions. Let me introduce the panelists to you. On my far right is Daniel DeSalvo, who is a senior fellow at the Manhattan Institute, as well as an associate professor of political science in the Colin Powell School at the City College of New York, CUNY. Dan's scholarship focuses on American political parties, elections, labor unions, state government, and public policy. He's the author of Engines of Change, Party Factions in American Politics, 1868 to 2010, and Government Against Itself, Public Union Power and Its Consequences. Dan writes frequently for scholarly and popular publications, including National Affairs, City Journal, American Interest, Commentary, The Weekly Standard, The LA Times, New York Daily News, and New York Post. In addition, he's co-editor of The Forum, a journal of applied research in contemporary politics. To my immediate right is Jed Britton, who is the Deputy General Counsel for Post-Secondary Education in the Office of General Counsel at the U.S. Department of Education. He advises senior agency leadership on legal issues relating to higher education. He also directs the Division of Post-Secondary Education within the Office of General Counsel, which provides legal advice to the Office of Post-Secondary Education and Federal Student Aid. Jed previously served as special counsel in the Office of the General Counsel, handling matters including the Title IX regulatory process and the department's negotiation of a new collective bargaining agreement. Prior to joining the department, he served educational and other clients in private practice on a broad range of legal issues. Jed graduated magna cum laude in statistics and philosophy from Brigham Young University, received his law degree from Yale Law School, and clerked on the U.S. Court of Appeals for the Ninth Circuit. Dan, I'd like to start with you. I'd love to hear more about your work in the area of public sector unions and your perspective on that.
I'm going to go to the podium.
Well, good morning. First, I'd just like to thank all of you for coming out or staying out to hear this panel, and I'd like to thank Adam and Andy for inviting me to come down from New York and speak to all of you this morning. So it's my pleasure to be here. Just to jump right in, I would say that really the debate over public sector unions in the United States has gone from 0 to 60 in the last decade, which was, you could say, before the Great Recession. We were just relying on me being more like William Jennings Bryan and able to speak loudly enough. You say before the Great Recession, public sector unions and their role at all levels of American government and politics was basically neglected by scholars, by journalists, by everyone. No one really talked about public sector unions. Then Scott Walker was elected, and Chris Christie was elected in New Jersey, and all of a sudden public sector unions were at the top of every headlines nationally and internationally, and they've stayed with us. The debate about public sector unions is really focused on state and local government and less on unions in the federal service. And this debate has obviously been very contentious. In one way, it's been highly polarizing between Democrats and Republicans, with Republicans being critical of the unions and Democrats being generally supportive. Although, if one gets into the weeds on this subject, one can find Democrats who haven't been altogether on the union's team, and that's been, in some ways, from President Obama and his race to the top education program, which really put teachers' unions on the back foot during his administration, to mayors like Rahm Emanuel in Chicago and his battle with teachers' unions, to governors like Andrew Cuomo in New York, my home state, battles with various unions and in the strongest union state in the public sector in the country. So what's the substance of this debate? Well, defenders of unionized government argue that unionization is good for public employees and encourages a professional workforce that better serves the American people. Public servants who belong to unions enjoy higher salaries, better health and pension benefits, and more robust job protections. Unions, we're told, are thereby ensure that talented people are attracted to and remain in government service. On the other side, in this debate, critics argue that unionization drives up the cost of government, reduces government performance, and creates inequities within the government workforce itself. These consequences are in some ways the result of the political power of public sector unions, where unlike in the private sector, government unions can influence employers, their employers more directly by making expenditures on political campaigns and by lobbying, as well as through collective bargaining. Therefore, the critics claim that public sector unions really distort democratic governance. So, in some ways, what I would like to focus my remarks on this morning is really how public sector unions interface with the administrative state, and I'll focus mostly on the federal service. And you could say that today's administrative state has clearly outgrown the notions of limited government that were ascribed to by the American founders. And as national administration has expanded, public employee unions at all levels of government have become an important political force in their own right. At the same time, I'm going to argue a little bit, unionization often works at cross purposes with, you could say, the original progressives at the early part of the 20th century, their original argument for bureaucratic expertise, which in a sense wanted to overcome the limits on government inscribed in the Constitution. And, in some ways, the reason for this is that public employees' occupational self-interest can sometimes infringe on expert administration. So you could say that today's administrative state is in a sort of halfway house. It neither reflects whatever the benefits of more limited government might be, but nor is it a model of bureaucratic effectiveness. So in some ways, the nub of the issue is that today's federal employees have their own interests, which do not always chime with the public interests. And unions that represent those workers seek to advance their interests. That's their job. And those employees' interests are usually in higher pay, better benefits, and more job security. Those are, you could say, the core occupational interests. And they're completely understandable. And while advancing those interests can be good for workers, taken too far, they can compromise the public's interest in effective public services and drive up the size and cost of government. So, given the fact that the administrative state isn't going anywhere, Republican efforts to, in a sense, reduce the size of government for the most part have ended in ashes, you could say that a central challenge is to strike a balance between what's good for public workers and what's good for the public. And so I just want to try to grapple with that challenge a little bit in my remarks. So just to start things out, we get the origins of unions and collective bargaining in the federal service. I'll give you a kind of thumbnail sketch or history of this problem. And this problem, in a nutshell, is in some ways, how can government deal with the political power of its own employees? This is a problem that goes all the way back, you could say, even to the Jacksonian era, when this problem was channeled through party machines, right? And the machines used patronage and other devices, which ended in sometimes in corruption and higher costs of government. So civil service reform, beginning at the end of the 19th century, was an effort to constrain or restrict the political power of government's own employees and the politicization, as you would say, of government jobs. And so for the federal service, this really began in the late 19th century with efforts to constrain postal workers who, in a sense, inundated Congress in the 1880s and 1890s with solicitations for better pay, better benefits, and so on. So Congress eventually passed in 1912 the Lloyd-La Follette Act, which in a sense, tried to limit and constrict, but also provide channels for federal employees to petition the government and, in some sense, organize into associations. But further efforts really to push forward full collective bargaining rights or unionization of public employees basically didn't proceed much after 1912. Between 1912 and 1960, this 40-year period, in part because, one, you had big events like the Boston police strike, which put on ice really most movements for the introduction of collective bargaining into government, and you had mostly presidents, including Franklin Roosevelt, who were opposed to the unionization of government employees in the 30s and 40s. So it's not really until the 1950s, at which point the AFL-CIO really merges, the AFL and the CIO merge, and really start to seek to pressure the national government to allow the unionization and collective bargaining rights for public employees. The main political rationale at the time was that basically the labor movement at that point was at its high point. It wasn't going to be able to expand much into the right-to-work states after the Taft-Hartley Act. So where could it grow or expand? Well, government looked like a ripe target. And there were various measures considered in Congress to grant federal workers collective bargaining rights in the 1950s. And it was John F. Kennedy's famous 1962 Executive Order 10988 that in some sense is called the beginning of collective bargaining rights in the federal service. And Kennedy issued this in part to stave off more sweeping measures that were being considered in Congress. Nonetheless, Kennedy's executive order did not provide for full collective bargaining rights. These words appear nowhere in the executive order. And indeed, the workplace issues of pay, benefits, and management's prerogatives to hire, fire, and transfer employees were all excluded from negotiations under that order. But it nonetheless provided an opening wedge that unions or associations of government employees would exploit. And this, in some sense, proceeded apace up through the Nixon and Carter administrations, and really until the passage, and this has already been discussed, so I won't go into great detail, of the Federal Labor Relations Act of 1978. In that statute, Congress indicated its desire to encourage collective bargaining in the federal service. The act states that collective bargaining is, quote unquote, in the public interest because it, quote, contributes to the effective conduct of the public business and, quote, facilitates and encourages amicable settlements of disputes between employees and their employers involving conditions of employment. Yet, it's important here to remember that and I'll come back to this point, that the subjects of collective bargains in the federal service are really limited to work rules, strikes are prohibited, and unions are forbidden from charging agency fees to non-members. So in that respect, federal unions, let's say, compared to those in state and local government since the 60s and 70s, all the way up at least until the Janus decision last year, have much smaller range of issues that can be collectively bargained, and they don't have access to union security provisions or union security clauses that would allow for agency fees, which in part explains why unionization rates in the federal service are lower than in, say, New York or California or New Jersey, substantially lower. So for thinking about what's the landscape of any further efforts to unionize the federal service were largely put on ice by the PATCO strike. In some ways, an illegal strike, which the union unwisely called, despite being discouraged from doing so by Tip O'Neill and others, really, forced President Reagan into a tough decision. Reagan reacted quite adamantly, and his fire and replace strategy really pushed back any efforts to further unionize the federal service and really put an end to striking in both the private and the public sector from that point really until the recent wave of teacher strikes this past year. So the contemporary landscape looks something like this. There's about 3 million federal employees, 666,000 postal workers, 7 million state government workers, and 10 million local employers, local government workers. So that just indicates the vast majority of the public sector workforce in the United States is in state and local government, not at the federal level. And I want to talk a little bit more about some of the implications of that in a moment. In terms of union representation, about 19% of federal workers belong to unions, whereas 64% of postal workers do, 33% of state workers, and about 44% of local workers are union members today. Now, again, the key point here is that collective bargaining rights in the federal service are much more limited. The subjects are more circumscribed. They can't charge agency fees. Nonetheless, and so many people have pointed out, well, what's the implications of, say, the Janus decision, the controversial Supreme Court decision from last term, which struck down agency fees in public employment or for public sector unions on free speech grounds. That is, they were a form of compelled speech. That decision has no application to the federal service and in a sense makes state and local government unions more like their federal counterparts. However, I would say it does have one important implication for public sector unions at the federal level, which is insofar as labor unions are federations, it's often been the case that, and there's some recent new political science scholarship on this point, which shows that basically the strong union states, the ones that, especially in the public sector, that could charge agency fees, as they pass on dues revenue and so on up the chain of the federation, the national federations could then cross-subsidize their weaker counterparts. So for AFSCME or the teachers' unions or SEIU, they could use that money to then help out unions in, let's say, right-to-work states of the South or Southwest, or their federal counterparts when they were in a political bind or confronted with political challenges. That's obviously going to be harder to do, and so insofar as the unions are taking a major financial hit when they lose agency fee revenue. There may be some downtick in union membership in state and local government as well, which would further erode national federation union revenue. So that's going to have important implications for the two primary federal government unions, the American Federation of Government Employees, that represents about 700,000 federal workers nationwide, and the National Federation of Federal Employees, which represents as much as smaller but older union, which represents about 100,000 workers in the United States. So really, when it comes to getting their way, what are public sector unions in the federal service doing? Well, they're doing two things. They're lobbying Congress, since Congress is still, in a sense, the executive here, the manager here, insofar as it decides pay and benefit and a lot of things that affect jobs. And the unions can't bargain over those things. And but it bargains over lots of really, we don't have time to go into all the nitty-gritty things that unions do when it comes to bargaining over work rules and how that shapes the day-to-day performance and constricts the rights of management in the federal service. And that's really where the political contestation is in federal government. So the real issue here, I think, is, and I think that Democrats in recent years, and some of the history with the Clinton and Obama administrations that's already been offered this morning shows, have been good at allowing for or finding ways to let collective bargaining be a mechanism for allowing voice and input by public employees, and there's probably a role for that. Republicans, on the other hand, are probably right in some and have some skepticism that role or voice or input onto agency decisions and day-to-day operations can sometimes spill over into constraining management decisions and acting in some sense as a sheet anchor against any change, and therefore that they'd like to see a little bit more management prerogatives. So it's how do you get, in some ways, this is really the challenge or difficulty. How do you get employee voice, which can be valuable for how matters are conducted, without compromising lots of other goals? And that's been the big challenge. And in some sense, this has been the responsibility, you could say, of Congress and the presidency. And it's really, in some ways, Congress that is the national administrator and chief, with probably an assist from the Supreme Court or the federal courts. And it's really the presidency and the president's 3,000 appointees that are really a distant third when it comes in some ways to managing the bureaucracy and the civil service today. And Congress has been, in some ways, driven by its desire to implement what many people have called proxy government, meaning the number of federal employees has held fairly constant for over 40 years. And how is that possible? Well, the reason, and I think this is summed up nicely in a quote from one of my teachers and mentors, a political scientist, Martha Durthick, in some ways summarized the political logic of Congress's efforts to institute proxy government to hold the federal workforce constant. And she writes, Congress has habitually chosen the medium of grants to state and local government, not so much because it loves the states more, but because it loves the federal bureaucracy less. Congress loves action. It thrives on policy proclamation and goal setting. But it hates bureaucracy and taxes, which are the instruments of action. Overwhelmingly, it has resolved this dilemma by turning over the bulk of administration to the state governments or any other organizational instrumentality it can lay its hand on, whose employees are not counted on the federal payroll. Hence the desire to outsource to contractors, the outsource to state governments, anything that doesn't increase the federal service, and partly to get around many of the constrictive and constraining work rules and elements of the civil service protections that have already been mentioned this morning. So that leads me to just a quick couple of final remarks, which is the direction of the President Trump's executive orders. In general, I think these point and push in the right direction, but one would also have to put them in this larger context of where most of the action is. Until Congress acts, major reform to the civil service is unlikely to occur. These can be important steps in the right direction. They certainly push right and send the right signals, but until Congress is going to be able to act in this area, if it can ever find an interest in acting in this area, things probably aren't going to go that far. If we even think about one piece of the official time is where federal employees are paid to basically do union work while technically on their regular federal job. In some sense, this is seen as a compensation for the fact that legally public sector unions in the federal service have to legally represent all workers in a bargaining unit, whether or not they're union members. And therefore, many are not union members and get the benefits of the bargaining in theory for free. So the official time is in some ways compensation for that. But if you look at the OMP data on official time, there's really, no sense of how much is really being, if you bore into it, there's all kinds of problems with it. There's no sense of how much official time is really being taken or how much it really costs the government. So these executive orders that put a spotlight on some of these issues, I think, are helpful and push in the right direction. Ultimately, long term, and I'll just close on this point, which is I think that the administrative state, insofar as it's here to stay, raises this issue, again, about the effectiveness and efficiency of the national and federal government. And Republicans, in some sense, have become much more interested in this topic as they've backed off a little bit on retrenchment. That is, Republicans want the administrative state today to be efficient and effective so that it can do things. Of course, the things that they want it to do, such as enhance national defense, homeland security, and border protections, and establish more market-oriented policies in areas such as education and climate change, are often things opposed by Democrats. And that's why, in some ways, making the national federal service more nimble and less costly are important goals. On the other side, of course, Democrats want to use the administrative state largely to create or enhance social programs and social insurance policies, although I guess I'm struck by how much, in a sense, concern about efficiency has fallen off the agenda of Democrats, and it's much more about expanding, and we can have strong unions at the same time, and these things are not in tension. So I'm struck by how much the debate has changed from the Democrats of the 1990s, where reinventing government was such a central theme, to today, where we're going to just expand the state without thinking about the effectiveness and efficiency of delivering these new policies and programs. But I'll leave it to others to take up those political debates. Thank you very much.
Jed, I'd like to turn the conversation over to you. Could you tell us more about the role of an agency's general counsel in reviewing and developing implementation plans for executive orders, having been involved in that process yourself?
Yes, and perhaps I will maybe also stand up here, this part. I guess I should start out by saying I very much appreciate the remarks from Dan and from the prior panel. I feel that I'm a relative novice in this area. As Joanne explained, I'm an attorney, had a broad litigation practice prior to this in private practice before coming into the government, but had not had any experience with federal labor issues, although I guess I should say I am the father of 4, so I feel like to some extent I've done my share of negotiation over benefits and working conditions and fundamental questions of whether people even have to do any work or not. I've addressed all of those, so I do have some experience, but my experience is really from the legal perspective and from a practical perspective. And so I thought I would just start out kind of talking about our experience at the Department of Education as something of a kind of a case study. We are very fortunate, I guess you could say, we think at the Department of Education, because we have a single bargaining unit for the entire department, which is unusual. I've come to discover as I've talked to people at other departments, like the Department of Defense, as was noted earlier. That's kind of the polar opposite, I guess, of our situation. And I should also start out by just explaining a sort of a disclaimer. As we're talking about implementing these executive orders, for the most part, we've actually not had any experience implementing the executive orders because our collective bargaining process all took place before the executive orders were in place. But for the most part, we followed the same principles that are underlying the executive orders, and so that'll be what I will direct my remarks to, is our experience in following those principles. And I think for the most part, it fits pretty well with the instructions that the administration has been given under the executive orders. So we started actually prior to this administration. We were on a prior collective bargaining agreement that had a 3-year term, and then it would automatically re-up after that unless one of the two parties or both gave notice that they wanted to renegotiate. And so back in October of 2016, under the Obama administration, the head of our labor relations group gave the union notice that we wanted to renegotiate, and then started the process with a ground rules negotiation. So that happened before we even arrived, and it was a good decision, I think, by our excellent career staff in the labor relations group. But the next part of the story is that we basically spent a year, approximately a year, almost a year, negotiating ground rules. And at the end of that period, we were essentially back to square one. So we had essentially nothing to show for it. I won't go into the details of that year-long negotiation process. I guess the highlight would probably be the point where after we had reached tentative agreement on a number of the pieces of the ground rules, the union changed chief negotiators, and the new chief negotiator showed up and said, I don't agree with, nor am I bound by any of that. So we're just kind of start over. So anyway, after that inauspicious start to things, we had sent over what we considered to be kind of a last best offer. They essentially didn't respond meaningfully. And so we approached the Federal Services Impasse Panel. So this is one of the various federal entities out there that's designed to guide and sort of help the process along and resolve disputes without there being strikes, which are, as was discussed earlier, are not really don't play the role in federal labor relations that they do in the private sector. And it was pointed out to us, actually, by staff at the Federal Services Impasse Panel that we didn't strictly need ground rules, although there are some rulings out there that say that we are required to participate in ground rules negotiation. There isn't actually a requirement that you actually have ground rules. You can negotiate without them. It is a nice thing to have them, particularly for the union, I think. They provides them with per diem and other kind of things that facilitate their ability to negotiate. But after a year of what we felt was bad faith negotiation by the union, we reached a point where we said, okay, well, let's proceed without ground rules on the negotiation. So we went to the next step, which was to move forward with a substantive proposal for this collective bargaining agreement. And we sent over, along with that, sort of a timeline for what we thought was a reasonable time in which the union could respond, which was the minimum we felt was necessary to be able to negotiate. So I'll pause in the middle of the story to discuss briefly what we put in that proposal. And the substance of it, I think, actually maps pretty well with a number of the provisions in these executive orders. Some of the features. First off, we proposed a collective bargaining agreement that had 8 articles. The prior collective bargaining agreement had 32. So that was just a big difference right there. There was a lot less being covered in terms of the substantive sort of requirements and guarantees in it. And I would say from a bird's eye view of the agreement, our perspective on this was that there are statutes and other laws that provide a lot of protections for the workers at the Department of Education. And then just basically the fundamental principle that management, the secretary, the leadership of the department was interested in having good workers doing good work and compensating them fairly and appropriately to retain them. And so from our perspective, we felt like a lot of what was in the prior agreement was unnecessary. They were principles that were going to restrict what the department, what the secretary could do. And so our goal in writing an agreement was to provide the minimum necessary, that which is required by the statute, and to make clear that the secretary would have the flexibility that she needed to move forward the mission of the department. And so for example, with things like telework is an issue that's often discussed, kind of a hot one as a substantive issue. We had a telework article in the prior agreement. We removed that article, did not have anything about telework, which I think some people's initial impression was, oh, telework is going to go away, there will be no telework. And our response to that is no. It's just not going to be governed by the collective bargaining agreement, right? So telework would be handled just like it is at most workplaces in the country, which is that there's a discussion between the person working and the supervisor about what is an appropriate level of telework given the kind of work you're doing currently, and what can be done remotely, and what is beneficial and efficient. And so it's allowed the secretary. We have made changes in our approach to telework since then, and the lack of some constricting provision in the CBA has allowed those changes to occur. So to touch on a couple of points in our proposal that fall under the provisions of these EOs that we're here to discuss today. First off, so there's the executive order on accountability and streamlining removal procedures. So one of our 8 articles is Article 7 addresses negotiation of grievances. And so the statute here, this is, of course, the Federal Service Labor Management Relations Statute, 5 U.S.C. Section 7121, expressly allows the parties to exclude from the grievance process essentially anything other than the sort of required issues that have to be included. And so we went ahead and proposed a long list of things that we felt should be excluded from the grievance process, including matters such as performance progress reviews, the informal assistance plans or performance improvement plans that we have as part of our procedural structure at the department, non-selection for promotion, removal of a probationary employee during his or her probationary period, generally adverse personnel actions with some caveats, claims alleging violations of the Fair Labor Standards Act, RIF actions, decisions regarding performance awards, spot awards, other types of awards, decisions regarding incentive pay, and then generally performance-based actions or disciplinary or adverse actions, again, with some caveats. So we proposed a broad list, and that fits pretty well with the kinds of encouraged principles that are laid out under the EO in that regard. And we felt like the negotiated grievance procedure was not the best way for these kinds of issues to be resolved. I think this is something the first panel covered pretty well in terms of the flexibility that we see in the private sector versus the kind of stratification and calcification you can see in the public sector. And we felt like, again, that would be an important flexibility that would be given the department if we were to remove those from the collective bargaining process. Another one of the EOs addresses primarily taxpayer-funded union time. So it was explained by Dan. Union time is where an individual employee of the Department of Education, for example, I can be on the clock, being paid by the federal government, receiving my benefits, et cetera, but instead of doing the job that I've been hired to do, I can be doing union activities. And we had a couple of our employees at the Department of Education who were on 100% official time, where they had a position description that talked about the kinds of work they would do and what they would get paid for, and then all of their time, instead of doing that job that they've been hired to do and were paid to do, was dedicated to union activities. So Section 7131 of the Federal Service Labor Management Relations Statute is the one that addresses union time. And so let's see, what we did was we of course started out with the statutorily required official time under the statute, and then put in the prohibitions on official time, which are also in the statute. And then beyond those required provisions, 5 U.S.C. 7131 D talks about agreeing on an additional amount of official time that's reasonable, necessary, and in the public interest. And the position that we took at the outset was that actually no additional amount of official time would be reasonable, necessary, and in the public interest. We felt like to the extent there were union activities that someone needed to be paid to do, that should be something that the union should pay for. And so we proposed, now in recognition of the fact that individual workers at the Department of Education would need to be the people carrying out those activities, what we did was we set up a system, sort of a bank of hours that the union would have to allow their workers to take leave without pay for union activities as needed, as long as their job necessities weren't immediate and didn't call for them to be there right at that moment. So we gave them the ability to use leave without pay time, to take time off of their official duties, to do union activities as needed, but restricted that to those stewards and other employees who really needed to be doing that. And then I guess the last of the executive orders is more, I guess, about the process of negotiating. It's also the one that, this is the cost reducing approaches executive order. This is the one that talks about the labor relations group, so we've been active in that since it's been created. It does, of course, suggest that you only take 6 weeks to conduct ground rules negotiations, so we blew that one. I guess we're sort of in that sense an example of what not to do. But it also does mention in the executive order that if your negotiations are delayed past what is a reasonable time period, then it suggests that the departments propose a new contract, a substantive agreement, and then implement that agreement if there's no timely response. So to go back to the history of our interaction with our union, that's what happened in our case. We put out our initial proposal, we gave the union a time frame in which to respond, and the union did not respond within that time frame. So I guess it should not have been too shocking given the year-long ground rules negotiation we had with nothing to show for it, but we were surprised once again that they chose not to, but we moved ahead with implementation. So since, I guess this was March of 2018, we've been operating under this new collective bargaining agreement. Unsurprisingly, we received an unlawful practices charge before the FLRA almost immediately upon implementation, and we've been responding to that before the Federal Labor Relations Authority. That's still in process. We hope to be vindicated from a legal perspective. I think this is an unusual case, and I don't know that it will make a lot of precedent for the future. The basic rule that we think should come out of this case is if you're a union, don't drag your feet quite that badly. Don't go for a year without anything to show from ground rules negotiations. We think that's sort of on its face unfair. And the unusual outcome in our case, I think, is a result of that bad faith action by the union. In fact, we found out later, I guess this was fall of last year, that AFG National had placed our local, this Council 252, in trusteeship. And this was based on allegations from AFG National of corruption and financial malpractice. So we're still now directly interacting with AFG National on all of our negotiations and sort of follow-on issues. I don't know the background of that, but I guess I'm not too surprised given what we saw in the negotiation that we conducted with the local. So in terms of our implementation since then, I guess the number one thing I would note is that we've seen a whole flood of litigation, starting with this unlawful practices charge, but then we've also, of course, seen a significant uptick in the number of grievances from the union on a whole variety of issues, some of them procedural, some of them substantive, and we are in the process of essentially litigating, or I guess arbitrating in almost all cases, those matters. Most of them, of course, depend on the threshold question of, was this process legitimate? But there are these substantive issues of the legitimacy of our proposals, and we're in the middle of that process. It's mostly run in our department out of our labor relations group, which is not part of the general counsel's office, but because of the legal implications and because our strategy and our approach was based pretty much entirely on the statute, the language of the statute, our office was involved, and we continue to be involved to some extent. So, I think I think overall we probably we could have learned some things, I think some valuable things from the executive orders if we had undergone this whole process after they had come out. But we're certainly supportive of the principles that are underlying them, and to the extent that we did follow those principles, we feel like it has turned out for our benefit and to the benefit of students and ultimately, the American public as we do our work at the Department of Education. So I will head back over to the panel.
Thanks, Jed. It's interesting to hear about how the process has gone on the ground for negotiating a collective bargaining agreement. Would you have done anything differently? Are there any lessons learned?
Yeah, that's a good question. We certainly didn't think, as I said, that the initial proposal that we put out there would become the collective bargaining agreement. We did try to write it in the best way possible, but it was sort of on a short timetable. So I think as we look back, there are some specific provisions that we might have written, sort of proofread or kind of gone over a little more carefully. But I think probably the biggest difference would have been just as I pointed out, earlier, the timetable for the ground rules negotiation. I mean, we really bent over backwards trying to accommodate the union, trying to get to a common agreement with them on that issue, and it's easy to say, hindsight is 20/20. It's easy to look back and say, oh, we should have cut things off after 6 weeks or at least 6 months. I guess the silver lining to that is that we certainly did everything that could have reasonably been expected or even hoped for in terms of accommodation in that process, and I think at the end of the day, it just sort of showed that we were making an attempt to negotiate in good faith, and the other side was not. And so, for better or for worse, we now have that sort of as evidence in the record as we move forward in these various appeals of litigation. So.
So for both of you, and Dan, I'll start with you. Where do you see these May 25th executive orders going, whether in terms of implementation, potential legal pitfalls?
Well, it was mentioned by a previous panelist. The bulk of all three of these executive orders have been are under injunction now by the district court judge, and those are under appeal. I gather that a decision is probably due by the appeals court by the end of June. I looked at some of the oral argument transcript in preparation for this panel. I guess I was struck by how much their three-judge panel. I was struck by how much I know there's not, according to Chief Justice Roberts, Republican judges and Democratic judges, but I was struck by the Republican-appointed judges were quite skeptical of some of the administration's arguments, and there is some innovative things in these orders. Now, that may not tell us exactly where they're going to come down, but they were fairly forceful in questioning the administration-side lawyers in this case. I don't know if that's telling or indicative. There's probably lawyers in this room who know more about how to read the tea leaves on these things than I do.
And we've I don't know, we're sort of lightly tracking the progression of the litigation. We take the position that it doesn't actually apply to us because we, of course, took all the steps we took well before the executive orders came out, and the points of dispute, as I understand them in those cases, that case is primarily about what's an appropriate role for the president in the labor negotiation process, and so can the president legally sort of order all the departments to do X, Y, and Z? But we had not been ordered to do so. We just proceeded in the normal course of negotiations, and it was really the sort of underlying principles, the reasoning behind the executive orders that motivated us, sort of shared sense of what is best for the federal government. So yeah, we occasionally get letters from Congress that imply that, the judge has issued an injunction. Doesn't that mean that you're stopped from proceeding with what you're doing? And we say, no, it actually has nothing to do with us. We're interested observers, but not really much more than that. So.
I was just going to say, if I might add on this, if you're thinking about how this plays into government efficiency and effectiveness, I think your sort of description of the collective bargaining process and now the subsequent litigation is telling about how costly this whole and time-consuming this is and can be, and why, in a sense, at least the thrust of the executive order that's trying to speed up the one on collective bargaining, speed up the collective bargaining process. This costs taxpayers a lot of money to do this. It takes a lot of time and takes up a lot of the court's time. Ultimately, to settle what would the American public, if they had any awareness of these issues, are very small issues. Whether you can telework or not, and whether that needs to be in the CBA, or whether a manager, and given that the vast majority of American workers are in the private sector and not covered by CBAs, they would take it for granted that their boss or manager could tell them how many days a week they could work from home or not. And so I would say that this just goes to show, I think, how much work rules can constrain government efficiency and drive up its costs. And the other thing I would say is that's important is if you think about this, this is a little bit because salaries are set by Congress, not by CBAs for the federal government, how much salary compression there is, meaning the top and bottom of the salary schedules are compressed, and which then in turn drives Congress to try to get away from this by contracting out, and this was part of Elaine's remarks earlier, is to get outside of this and either push things to the state governments or push things to private contractors to avoid this whole process entirely.
Do you think that the mechanisms in that executive order you mentioned on the process, do you think that they would be effective at creating some of these efficiencies?
It's hard to say, but I'd say it's worth trying. And insofar as the CBA, if you read the executive order, just tries to establish some basic timelines. Don't take a year to set up the ground rules before you've even begun the actual negotiations of the CBA. That at least give you some metrics about how long negotiations at different stages and what's being negotiated should actually take, and that would at least produce some data or some public expectations about what those should be, rather than this really open-ended process which can go on for months and months and years that we have now.
So one more question for me, and then we'll turn it to the audience. What do you think, I mean, where do you think we're going with these principles? Will future administrations embrace them or discard them? What's the future look like?
That's a good question. I mean, I think that, well, to go back to what Dan was just talking about, I think that the motivation, I can totally understand the motivation, I think, behind, if I were representing a union, for example, I think I would be probably serving my client well to say, let's delay things as long as we can and sort of cross our fingers and hope there is a change in leadership. Because I do think, they had a very different experience negotiating with the last administration, for example. That's where our prior collective bargaining agreement had been negotiated. And so, I guess in that sense, they're probably, doing a good job if they're delaying things, ground rules for a full year and kind of trying to push things off. It probably would have continued. I mean, we certainly would have continued to negotiate if they had responded in a timely manner to our initial proposal. And who knows how long that process would have gone on for. So I do think that, I think it's an appropriate move by the administration, by the management side, to say, no, this is not in our interest. It's in our interest to move forward, get this issue resolved, and kind of put it behind us. And so, I guess I don't know. It's an interesting question. If you are a future administration that is more in line in terms of your policy preferences with the unions, and you see them more as partners who agree with you on things, as was pointed out by the prior panel, I think I could imagine them changing some of these principles. Although I think some of them are just kind of good government principles, regardless. I think the labor relations group idea from across the administration, I would think that a future administration would keep something like that in place. Regardless of their sort of policy preferences.
I guess my view would be you really need Congress to act, because otherwise these things can, as a prior panel indicated, there can be a lot of change from one administration to the other when it's just being done through the executive. If Congress were ever able to take an interest and actually act in this area and do some of the things, say, along the lines that would allow for greater flexibility on the part of management to design the things that they wanted to do, I think even if Democrats might oppose such a law at the beginning, might find it congenial once passed. To take another example of this, from the state level, which is to say Democrats in Wisconsin opposed Act 10 tooth and nail. But now that it's been passed and localities are reaping enormous savings, especially on healthcare and other areas, the new governor, repealing Act 10 is not on his agenda because he sees in many ways the savings and benefits and other policy initiatives that he'd like to pursue and the money that frees up. So one could imagine a similar process were something to ever get over the hurdle, but my sense is for these principles to really be instantiated, you'd need a reform of the 78 law.
I saw a question here.
Yeah, actually I wanted to make 2 points. One is on motivation. Yeah, 2 points. Is this one on? Yes. Okay. One is on motivation, and in my experience, unions always play the waiting game. The time horizon of political management is certainly 4 years on presidential elections, possibly an 8-year term, but within agencies, it's typically much shorter than that. Agency leadership, political leadership will turn over at the secretarial level 2-3 years. Subordinate managers, non-career SESers, certainly no longer than that, less than that. So it's in their interest to play the waiting game, and they do. That's part of their strategy in any negotiation, whether it's the ground rules bargaining or anything else, just play it out. And I certainly saw it at the NSBS. And their strategy paid off in that case. Congress turned over, President turned over, boom, it was gone. Yeah. Second point is on outsourcing. Elaine had mentioned the motivation of pay compression in the government. I think a more important consideration on outsourcing from the federal side is not so much pay. There are costs associated with outsourcing, the overall contract and such like. It's getting the work done in a way where you can control the quality, and if you're not happy with the quality of the work, you change contractors. That is a major motivation, much more so than any pay consideration for individual actors. And the unions and their strategy play a great role in that, because you can't hold people accountable. You've got to go through the CBA on rewards, on punishments, and things of that sort. Why bother with any of that? Just contract it out, let the contractor deal with all the compensation and performance issues rather than having to run it through the MSPB and out to the courts and every place else.
Do either of you have comments on that or responses?
I agree.
Okay. Yes, sir.
Thank you very much. As I look at the former panel, and you guys too, I said generally you're trying to deal with something that really is beyond your professional competence, etc., because it's a different subject matter, even though you're trying to put it in the context of what you are known, conventional thinking. I have said many times to Trump that what he has to do, and he's going to do it very soon. I've said to him many times, especially when he faces a setback, look, I've told you for what you want to accomplish, you have to launch your own cultural revolution in America like Mao Zedong did. Because if you compare Trump's position in America, both domestic and foreign, and you take what Mao Zedong was facing and why he launched the Cultural Revolution. One, because his party was not supporting his people's goal, and the bureaucrats were not being read enough, which is what Trump is facing, and also externally. So very soon, I hope he's going to convert his rallies to launching his cultural revolution. He usually comes to my view after he faces some serious series of setbacks. So what you all are talking about, for it to be done, not just Trump, any other lead president that comes in who want to make significant reform in the federal bureaucracy, we cannot be doing the usual things that you all are talking about. It has to be done in a different way, where you appeal to the American people to say, look, your taxes are being wasted because this bureaucracy, they're sitting there on their asses, just consuming and not doing work. And most of the programs that they are pursuing should have ceased existing a long time ago if they have used private sector analysis and approaches. I am a PhD in public administration. When I was a graduate student in 1973, San Diego State University School of Public Administration, I was one of the people inside the Association for Public Administration who are with the private, to bring private sector activities into public sector analysis. And when I worked for the state government of California for 30 years, both the top executives, 90% of them in state services, and the union leadership hated me because I said we could slash the management 60% and 40% of the regular staffing, and the people of California will not notice any significant decline in public service. So what you are talking is good, but it's old school. You need to come bring a new approach to get it done.
Any responses?
Yeah, it's nice to be in Washington, but I feel like I haven't left New York. Everyone's ready for the Cultural Revolution. I guess my own trepidation about that is the number of deaths incurred by the Cultural Revolution. So I hope that isn't coming anytime soon.
Hey, can I ask just one question in conclusion before we go to lunch? Dan, you've studied this for so long, and you observe we seem to have had some different inflection points at different times, like with Walker and Christie when they were elected. I mean, looking now at the public sector union issue, in the aftermath of Janus, and in light of transformations in the economy, just changes in career paths for younger generations, and at the same time, just the decline of unionization in the private sector. I'm curious if you could just peer into your crystal ball and just give us like an outline sketch of what you think public sector unionization could look like in 20 years?
That's
You have 30 seconds.
30. It's really hard to do. I mean, I think that probably expectations on both the left and the right that the Janus decision would devastate union membership has not proven to be the case, and it's going to be a much slower decline, if there's that much decline at all in sort of membership in state and local unions. It's going to be and states are doing a lot now, New York, California, and everything, to prop things up. So I wouldn't expect that, you know, obviously in 20 years, lots of other laws and things could change. But in one way, there's probably a lot of forces for continuity from where we are now, but there's going to be a huge amount of pressure on state and local governments, finance coming from the pension problem and from retiree health care liabilities, which may force a little bit more innovation in the public sector workforce than might otherwise be, but it's really hard to see how that might play out.
Interesting. Well, I guess we'll find out. I know there was one question that we didn't get to. Thank you for your patience. Sorry I didn't get to it. We're going to break now for lunch, and we'll reconvene in just a little bit for our keynote speaker. But please join me in thanking both of our speakers, Jed and Daniel. Thank you, ma'am.